Hey everybody, welcome to Hollow Point Defense. I'm going to talk to you today about school zones. I get a lot of questions and emails and messages regarding the 1,000-foot Gun-Free Safety Zone Act. So let's dive into that a little bit. I'm going to give you the federal side first, then we'll jump into what the state says, and it's confusing. It's a lot of bullshit, to be honest with you. So let me start out with this. If you're thinking of taking this course for this reason, because some training place, because there are several in the valley here, that state that you need a permit to carry through a school zone. They're full of shit and they're just trying to screw you over for a little bit of money. So let's keep you from getting screwed. If you want to get it for that reason, that's fine. But let's not get it because they told you that. So let's show you what this says. The Crime Control Act of 1990 is what it's actually called. It's Title 18 U.S. Code 922 Q3A. And what it states is, except as provided in subparagraph B, it shall be unlawful for any person, knowingly or with reckless disregard for the safety of another, to discharge or attempt to discharge a firearm that has moved in or otherwise affects interstate or foreign commerce at a place that a person knows is a school zone. Let's go to the definitions real quick. The term school zone means A, in or on the grounds of a public, religious school or private school, or B, within a distance of 1,000 feet from the grounds of a public, religious school or private school. When they say school, it actually means any school that provides, let's see here, elementary or secondary education, aka high school. Religious, because they have that state requirement plus the religion aspect to it. So those places right there is what school zone means. Get rid of that piece of shit. So let's get back to the confusingness. Exceptions to the rule under Title 18 U.S. Code 922 2A does not apply to the possession of a firearm on private property, not parts of the school zone. So your house that happens to butt up against their property doesn't count. Don't need a permit for that. It's your private house. They can't do squat about it. If the individual possessing the firearm is licensed to do so by the state in which the school zone is located or a political subdivision of the state, and the law of the state or political subdivision requires that. Before an individual obtains such a license, the law enforcement authorities of the state or political subdivision verify that the individual is qualified under law to receive the license. They're going to run your background, make sure you're not a felony, child molester, any of that other crap. Which if you bought a gun, you're probably not any of those anyways. There's more to this, but that's the point that everybody's getting kind of screwed on. Under Title 18 U.S. Code 922 3A does not apply to the discharge of a firearm on private property. So if you shoot somebody at your house or even an accidental discharge, private property, the school zone has no effect on it. Or if you're going to the school for some kind of gun safety class, which some of them used to do that, I don't know if they do anymore. Police within the official capacities of their duty. That's the federal law part of it. Nowhere in there it says you can't drive through, and if you go look up the law like I did, read it all, there's nothing in there that says you can't drive through the school zone with your gun. Christ's sake, from where I live, there's 3 schools I pass within 1,000 feet just to get to the freeway. There's no other way I can go. Even if I go a different way, I'm still passing 1 or 2 at least. So on main public thoroughfares, you don't need the permit to carry through a school zone. Now, if you go into the school grounds, it's a little bit different. Let's get what the state of Arizona says. And I'm only teaching this from a state of Arizona point because that's where I teach for the Arizona permit. Really don't care about another state. If you do, then you need to go traverse that state and find out what they say. But let's go with state of Arizona. What are the school exceptions when carrying concealed weapons? This is straight from the Arizona Department of Public Safety website. Please see below for school exceptions, concealed or not, aka permit or no permit. You are an adult in a vehicle and the firearm is unloaded before entering school grounds. Furthermore, if you must exit the vehicle, the firearm must remain unloaded, and be secured, locked within the vehicle out of plain view. Use caution and common sense if you must exit the vehicle with a firearm to secure it in the trunk. Avoid causing a potentially serious disturbance. Before I move to the next one, if you're going to get out of your car with a gun, you almost should expect that with today's soccer moms and overly paranoid people. Leave it in your car, bury it somewhere, put it in the glove compartment, whatever you got in there is safe, lock it up, but not around people. If little Susie's next to you and her mom or dad, and they see that gun, they can call it in, and you're going to have some problems. You may not get in a lot of trouble, but you're going to cause some problems. So be smart. Again, even DPS says common sense. We know it's not all that common, but use it. You are an adult attending a firearms-related hunter safety or participating in a school program that required you to bring or possess a firearm, and the training event was scheduled and approved by school administrators. This exception also applies to a juvenile accompanied by a parent, grandparent, legal guardian, or certified hunter firearms safety officer acting in the permission of the parent or guardian. The firearm will always be unloaded before entering school grounds. It should be placed in a case to avoid causing potentially serious disturbance. Somebody may not know what's going on there, see you walking in with a rifle on a sling. Guess what's going to happen? We can all figure that one out. Additionally, designated employees of a school may order a person off the school property if that person is believed to be interfering with school operations. School boards may also enact specific and more restrictive rules governing firearms and deadly weapons on school grounds, ARS 132911. You can go look that up, and maybe I'll do something on that one later. But the interference with or disruption of an educational institution. This is violations, classifications, and definitions. Any deadly weapon, dangerous instrument, or explosive that is used, displayed, or possessed by a person in a violation of a rule adopted pursuant to this subsection shall be forfeited and sold. In other words, if you use your gun on the school grounds for whatever, they're going to take it and sell it. You're not going to see it again. Notwithstanding subsection D, which is what I just read to you, the governing board of an educational institution may not adopt or enforce any policy or rule that prohibits the lawful possession or carry of deadly weapons on a public right-of-way by a person or on or within a person's means of transportation. See how confusing that was? But that Crime Control Act of 1990, guess who put that one into it and got it passed? Let's see, you guys will know this one really well. It was Senator, let me look at this so I can say it to you like it is. It was introduced in the Senate as Senate Bill 3266 by Joseph R. Biden Jr. on October 27th, 1990. So you can figure out who the hell put that in there, because that moron's up there right now in the big chair. So when it comes down to the 1,000-foot gun-free safety zone act, the 1,000-foot rule, don't need a permit. It ain't gonna hurt, but you don't need it. Main public thoroughfares do not count. I read you the federal law word for word on that section. Nowhere in there it states that you can't drive through there.